Greetings to the Parliamentary Working Group. My name is Ryan Mohammad Riaz, and thank you for inviting me to talk about the Land Registration Act 2002 and whether it remains fit for the purpose of accessibility, efficiency, and transparency. To understand this, I will start by giving a brief introduction to the land registration system, the extent to which the mirror principle works in practice, and my suggestions to improve the current system for the future. Without further ado, let's begin. The land registration system was introduced in 1925 to eliminate the obstacles caused by the previous system of title to land, particularly the system relying on the title deeds. This is a legal document showing evidence of ownership of a property. Historically, title to land needed to be proved by title deeds. It was considered as an inherently problematic system due to the potential for such documents to be misplaced or lost by landowners, resulting in possible failure to provide a good title to land. This rendered the conveyancing process complicated and lengthy. However, the 1925 Act was also criticized as being unsatisfactory and unfair, largely due to the operation of the doctrine of notice, where an individual with an equitable interest in the land would have that interest swept off the land if the purchaser was a bona fide purchaser of the legal estate for value without notice. That's why the Land Registration Act 2002 was established, aiming to achieve faster, cheaper, and more reliable dealings in relation to the conveyancing and ownership of land. In order to reach this objective, the Land Registration Act 2002 was underpinned by three fundamental principles: the mirror principle, the curtain principle, and the insurance principle. Based on these fundamental principles, the Land Registration Act 2002 was founded with the purpose of reflecting land ownership more completely and precisely than its predecessor. So, what is the mirror principle? The mirror principle refers to the idea that a registration of a land title, which means the official record of who owns the land, must reflect all the important and significant details that a purchaser must know before buying the land. So, if you're thinking of buying a piece of land, you should be able to look at the title and see all key details such as who owns it, if there's any loans or rights under it, just like a mirror. As Gray and Gray 2008 put it, the objective of land registration is that any prospective purchaser of registered land should always be able to verify by simple examination of the register the exact nature of all interests existing in or over the land which he proposes to buy. In order to achieve this, the Land Registration Act has combined a system of voluntary and compulsory registration via Section 4 and 3 of the Land Registration Act 2002. Under Section 27 of the Land Registration Act 2002, a wide range of interests, which in this context refers to the right someone has over a piece of land, must now be registered on in order to have legal effect. These include leases of more than 7 years, future leases of any duration, legal easements, and legal mortgages. The curtain principle, on the other hand, is the concept that land registration may allow certain equitable interests attached to the land to be hidden from a purchaser's view. This curtain, however, does not affect the validity of any transaction on the registered land as long as the details of the registration reflect the validity of the title. It seeks to keep beneficial interests under a trust behind a curtain, thus of the register. The idea is that the purchaser of the land should not be concerned about the matters behind the entry to the register and rely solely on the register to understand the current state of ownership. This simplifies conveyancing, making it easier and faster for the land to be bought and sold. While the curtain principle protects a person from having to investigate hidden interests, it does not mean those interests are invalid. In many cases, a transaction still overreaches these interests. The effect of an overreaching interest is that any equitable interests that are shifted from the land itself onto the money that was paid for it. This means that the buyer gets the land free of those equitable interests, and the person with those rights now have a claim to the money and not the land anymore. Section 2 of the Land Registration Act 2002 states that overreaching can be constituted if the rights exist behind a trust or strict settlement. The sale is made in circumstances where the transaction is made by at least two trustees or a trust corp under a trust of land. Transaction is made under provisions of the Settled Land Act 1926. Transaction is made under an order of court. Transaction is made by a mortgagee or personal representative. The case of City of London Building Society and Flag 1988 shows that overreaching will generally prevail over overriding interests. Finally, the insurance principle. The insurance principle refers to the guarantee secured by the state that any loss incurred by a registered land resulting from reliance on the conclusiveness of the land registry by a land purchaser will be compensated through a statutory indemnity system. This means that if someone buys the land by trusting the information in the official land register and later finds out there was a mistake that causes them to lose their money, the government will pay them compensation. It is like a safety net. The state covers that loss if the register was wrong and you suffered a loss because you trusted it. The loss may have various causes, even fraud or forgery, except for a few expressly stated exceptions, such as loss caused by fraud of the injured party. This shows that the curtain principle and the insurance principle walk hand in hand. So, does the mirror reflect the reality? Not always. The mirror principle assumes that title recorded in the register is a true reflection of the legal rights. In order for the mirror principle to be met, both the land itself and the interests in it must have been registered. However, it is almost never the case in reality. Not only is 10% of the land unregistered, there are many interests that are recognized by the law but not recorded in the title register. Even though the Land Registration Act 2002 improved the system, the act was criticized for keeping the doctrine of overriding interests. Overriding interests are not recorded in the land register but are nonetheless binding on the purchasers, therefore representing a crack in the mirror principle. This creates a gap in the system because the register no longer gives a full and clear picture of ownership. Imagine a buyer purchases a registered land, only to discover that a person with an overriding interest has a right of occupation. The most important categories of overriding interests which remain in force are legal leases that are 7 years or fewer, interests of persons in actual occupation, and certain legal easements. The law relating to these interests can be found in Schedules 1 and 3 of the Land Registration Act 2002. A person arguing for such overriding interests should satisfy three elements. A person has interest in the land, a person has actual occupation of the land, and occupation would be obvious upon a reasonable inspection, or the purchaser knew the client had an interest. The most complexity can be found in the concept of actual occupation. Various cases, such as National Provincial Bank Limited and Ainsworth 1965, have clarified that a person's actual occupation could not satisfy the demand of overriding interests without an interest in the land, which has to be a proprietary interest instead of a personal right. In Williams and Glyn's Bank and Boland 1981, it was stated that actual occupation is a question of fact and not a question of law. This shows that what can amount to actual occupation can also be challenging at times. In Link Lending Limited and Bustard 2010, the claimant held to be in actual occupation despite of being detained in a psychiatric unit. She intended to return and thus was found to be in actual occupation. Buyers can only find out about these rights by making enquiries or physically inspecting the property. This undermines the curtain principle. What amounts to a reasonably careful inspection can also be argued to be subjective and unclear. On top of that, overriding interests make it harder to move towards electronic conveyancing, which is meant to expedite and streamline the conveyancing process with accuracy. The doctrine of overriding interests therefore conflicts with the stated fundamental principles of the land registration system and thus hinders the system from fully achieving its legislative intent. Originally, the justification for this was that overriding interests were just minor liabilities that were impractical to register. However, many overriding interests, such as short leases, are actually significant and can seriously affect a buyer's rights. So what can be done to improve the Land Registration Act 2002? I recommend three key reforms. First, implementing a mandatory registration. Requiring compulsory registration for all land can eliminate or reduce the 10% of the unregistered land. Every interest worth recording would be brought within the register. It is important that land should be registered as much as possible to consolidate the mirror principle. Doing so can make things much easier for enhancing e-conveyancing, the second reform. An online trustworthy register can lead to faster transactions, reduce errors, and prevent fraudulent cases. It can also increase accessibility for everyone, and fully perform the intended objectives of the Land Registration Act 2002. Limiting or reducing overriding interests strengthens the mirror principle, as all binding rights are on the register and not hidden. Since overriding principles correct the mirror by hiding certain rights, further limitation or removal of these interests would restore the mirror's clarity, making the register a more reliable tool. The scholar Chris Bevan, in his journal, compares reforming overriding interest to the Japanese art of kintsugi, where a broken pottery is repaired with gold to make it stronger and more beautiful. In the same way, reforming overriding interests could create a stronger and clearer land register, one that acknowledges its flaws but still moves towards a better system for the future. So in conclusion, the Land Registration Act 2002 was a major step forward in making land ownership clearer, faster, and fairer. But as we've seen, the system still isn't perfect. The mirror principle, which should let us see exactly who owns what at a glance, doesn't quite reflect the reality. That's because of two key problems. Some land is still unregistered, and certain rights, overriding interests, remain hidden, creating uncertainty for buyers. The reforms I've suggested today, making registration of all land compulsory, enhancing e-conveyancing, and reducing overriding interests, would help build a system that truly meets the goals of accessibility, efficiency, and transparency. These changes would restore trust in the land register, making buying and selling the land simpler, and give everyone, from homeowners to big developers, the clarity they need. If we want a land registration system that truly serves its people, these reforms aren't just ideal, they are necessary. Thank you.